Want to learn about the 2025 California labor and payroll law changes? You're in the right place. Plus, we'll also look at 2026 and talk about some of the changes that are expected for that year. The key labor and payroll law updates taking effect in California in 2025 impact how we calculate pay, manage employee leave, and determine exemptions. Staying current with these changes is important for employers to avoid penalties and to ensure compliance, and important for employees to understand and protect their rights. By the end of this presentation, you should feel confident in understanding what's new and what it means for payroll operations in California. As of January 1st, 2025, California's minimum wage increased to $16.50 per hour for all employers, regardless of how many employees they have. This increase also impacts exempt employees because to qualify for exempt status, an employee must now earn a salary of at least twice the minimum wage on a full-time basis, which amounts to $68,640 annually. Failing to meet this threshold could result in misclassification of exempt employees if they earn below that annual salary and expose the employer to potential legal issues. It's important that payroll systems reflect this change and that HR reviews current employee compensation. These increases often have a ripple effect on internal wage scales and benefits calculations. Certain industries in California now have their own mandated minimum wages. For example, fast food workers are guaranteed $20 per hour as of April 2024. Healthcare workers have seen their minimum wage rise to $23 per hour in 2025 and then to $24 starting July 1st, 2025. Additionally, many local jurisdictions such as San Francisco, Emeryville, and Berkeley have their own minimum wage ordinances that are often higher than the state's rate. Payroll professionals must ensure their systems are updated to reflect these industry and locality-specific rates. Ignoring local wage ordinances can lead to costly compliance issues. And keep in mind that many employees work remotely from home. Under California labor law, remote workers are subject to the wage rules of the work location, even if the employer's main office is elsewhere. So if the worker lives and works from home in Emeryville, California for a company located in Los Angeles, the worker would be paid Emeryville minimum wage of $19.90 per hour as of July 1st, 2025, rather than the Los Angeles minimum wage of $17.87 per hour as of July 1st, 2025. Exemption rules also saw updates. Computer professionals now must be paid at least $56.97 per hour or earn an annual salary of $118,657 to qualify as exempt under California labor laws. This is a significant benchmark that employers must monitor, especially in the tech industry. The salary basis test still applies, which means the employee must be paid on a salary basis and perform exempt duties. Employers should conduct a classification audit to ensure employees meet both the salary and duties tests. These thresholds are indexed to inflation and reviewed yearly, so ongoing updates are expected. There are new requirements around employee leave. AB 2499 expands protected leave to victims of crimes or abuse, as well as their family members, providing more flexibility and security. AB 2123 restricts employers from forcing employees to use vacation or paid time off before they can access California's paid family leave. This preserves an employee's right to state-funded benefits. AB 1870 updates workers' compensation postings to include a statement that workers have the right to consult with an attorney. These changes aim to empower workers and enhance their understanding of their rights. It's essential to update HR policies and physical workplace postings accordingly. SB 988 requires a written agreement when hiring independent contractors or freelancers for work exceeding $250. This law also sets timelines for payment to avoid wage theft. SB 1100 prohibits employers from requiring a driver's license unless it is a job necessity, which prevents discriminatory practices. These laws reinforce the need to clearly define employment status. Misclassifying workers as independent contractors when they're effectively employees can result in large penalties. Ensure your contracts are up to date and that classification procedures align with both state and federal standards. SB 639 eliminated subminimum wages for workers with disabilities effective January 1st, 2025. California joins the growing list of states that have phased out this practice to promote wage equality. Employers who previously relied on special wage certificates must transition all workers to at least the standard minimum wage. This change reflects a broader shift towards workplace inclusivity and fairness. Payroll systems and compensation plans must be updated accordingly. Training HR and payroll staff on these changes is also key to avoiding unintentional non-compliance. Some employees continue to receive subminimum wages, though, such as learners or trainees with no prior experience in that occupation can't be paid 85% of the minimum wage during their first 160 hours. Student employees at organized camps may be paid 85% of minimum wage for up to 40 hours per week. Parents, spouses, or children employed in sole proprietorships or partnerships, but not corporations or LLCs, are exempt from minimum wage orders. The same applies to prison inmates who are not subject to minimum wage laws. California has introduced new workplace safety measures. SB 1105 allows agricultural workers to use paid sick leave during extreme heat emergencies, which is critical given increased frequency of heat waves. AB 2738 establishes mandatory safety standards and training for workers in live events, such as concerts and large public gatherings. These laws reflect California's growing focus on emergency preparedness and worker health. Employers should review their emergency leave policies and training programs, ensuring compliance not only avoids penalties, but also promotes a safer and more supportive work environment. AB 2299 requires that employers clearly post whistleblower protection rights using a font size no smaller than 14 points. This ensures employees are aware of their right to report violations without fear of retaliation. California also introduced major reforms to the Private Attorneys General Act, PAGA. These reforms limit excessive penalties, allow cure periods for violations, and place caps on how long claims can go back. The goal is to reduce unnecessary litigation while still protecting workers. Employers should reassess their labor law postings and consider internal audits to proactively fix issues before they escalate into legal claims. Several other laws are also worth noting. Starting in 2025, insurance providers must include coverage for in vitro fertilization, IVF, and other infertility treatments, although religious exemptions apply. The state has extended the use of remote court hearings through 2027, which may affect employers involved in labor disputes or hearings. Additionally, all student ID cards must now include the 988 crisis line, reinforcing the state's commitment to mental health support. While not strictly payroll-related, these changes reflect evolving responsibilities for HR and benefits departments. Staying informed is key for both payroll and broader HR compliance. Looking ahead to 2026, healthcare workers will see their minimum wage rise again to $25 per hour starting July 1st. This is part of a multi-year wage schedule passed in 2023. Meanwhile, Proposition 32, which would have raised the state minimum wage to $18, was rejected by voters. However, many cities in California are planning their own increases, so local wage rates could continue to diverge from the state baseline. It's important to stay aware of these regional shifts. This will require constant payroll system updates and employer awareness. These legal changes have practical implications for payroll systems. Employers must verify that all exempt employees meet the new salary thresholds and that workers are correctly classified. Payroll software should be updated to reflect the new wage laws, leave entitlements, and local rates. Sick leave policies may also require revision to comply with new rules around usage and eligibility. Additionally, physical postings at the workplace, such as work wage orders or whistleblower notices, must be updated. Being proactive about these changes will minimize legal risk and payroll errors. To summarize, 2025 brings significant updates to California labor and payroll laws. Minimum wages are rising across the board, and certain industries have separate requirements. There are new rules around leave classification and notice postings. Looking ahead, 2026 will see even more wage increases, particularly in healthcare. Payroll professionals need to stay educated and maintain open communication with HR and legal teams. Accurate payroll starts with the understanding of these laws and ensuring systems and policies are updated accordingly. In closing, consider what challenges employers face when adapting to these legal changes. For example, how might small businesses manage higher payroll costs? Or how can multi-location employers keep up with varying local wage laws? Also, what tools and resources can payroll professionals use to stay current, such as newsletters, legal updates, or continuing education? These discussions can help deepen your understanding of the practical application of labor laws. Also consider what changes you would like to see in terms of labor and payroll laws.